States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner, and welcome, counsel. Judge Bennett, Judge McBrayer, and I are honored to be the panel to hear your arguments this morning. We will conduct the hearing in the same manner as if all of us were in the courtroom together. So there'll be nothing different about today's proceeding. Of course, your arguments are being live streamed as we speak and will be posted on the AOC, the Administrative Office of the Court's website in a few days for subsequent viewing by the public, in addition to their ability to observe today. Both sides have 15 minutes, and I know the appellant has elected to reserve some of your time, and that the clock will be programmed accordingly. Unless there are any other matters or announcements, Mr. Hibner, please call the case.
Kabir Afzali et al. Versus Shirzad Etemadi.
Mr. Notestein.
Good morning, members of this honorable court. I'm Robert Notestein of the Notestein Law Firm. We represent the appellates. For the ease of communication, I'll refer to them as the Afzalis, and they're two brothers. I would like to reserve 3 minutes, as the court mentioned, for rebuttal. I will try and be relatively brief this morning because I think our brief really states our position pretty well. It lays out the issues, it lays out our argument in the law. But clearly, I wanted to point out the trial court basically dismissed our complaint on the basis of res judicata waiver, and then also basically stated that we waived the right to challenge this easement issue when the closing occurred in 2018. There are some relevant facts that we summarized that I think are really important. The facts that are really unusual are that Mr. Etemadi, in the record, created and recorded on May 5th, 2018, a 24-foot ingress and egress easement across the property, which he later sold to my clients. He created it and recorded it during litigation with a lien lis pendens in place and did not tell anyone. And frankly, when the pending litigation, which I call the 2016 case, when that was settled later that year, well, very soon thereafter in May of that same year, my clients agreed in a settlement agreement to purchase the front tract on Knowlesville Road. It's about a 64-foot wide commercial lot. They agreed to do that. They signed a settlement agreement with Mr. Etemadi. Mr. Etemadi agreed in the settlement agreement to give them good title. And then right after that, counsel for Mr. Etemadi, and I believe it's in the record, counsel for Mr. Etemadi advised counsel for the Afzalis that there was some kind of easement on the property. After investigation, the easement proved to be a 24-foot wide ingress and egress easement created by Mr. Etemadi, and the easement would serve an adjacent lot he owned and intended to keep, and he just didn't tell anybody until after the settlement agreement was signed. The Afzalis actually went back to the 2016 trial court and said, you know, we need to set aside the judgment or something. There's a breach of the settlement agreement. Chancellor Bonnyman did not see that position and basically did not set it aside, and that case ended. But in the argument on that
Mr. Notestein, why doesn't that decision by the chancellor in 2016 resolve all claims?
That decision, the way we're looking at it, that decision was not a decision about title. It wasn't a decision about the easement. The motion that was filed in the 2016 case was to open it up again, to set aside the order so the court could look at the settlement agreement, see if the case was really settled. And that's what the crux of that motion was. The judge denied that. And so the case closed. But in their argument, Mr. Etemadi's attorney, in that motion, they said, well, your remedy, Afzali, is to file a separate suit to enforce the settlement agreement. Their own counsel said that, and that's in the record. And that's what happened. Mr. Afzali's attorneys turned around and filed a suit to enforce the settlement agreement and, in effect, to quiet the title. That was not an issue in the prior case. The prior case was a breach of contract that was settled where Mr. Etemadi agreed to sell. And that's why we don't believe waiver and res judicata applied. We don't believe the prior case, the 2016 case, was on all four corners with this case. This case would be a breach of the settlement agreement case and a suit to really quiet the title. And I think that's very important. One other thing I think the court might want to look at is when Mr. Etemadi created the easement in March of 2018, he owned the tract that the Afzalis now own. He owned the tract behind it. We cited a case, Vanderbilt versus Williams, where basically the court said a fee, if you have a fee interest and an easement interest, they cannot exist in the same party at the same time. And what Mr. Etemadi did, he owned both tracts. He created this easement, didn't bother to tell anybody, and then he sold it to our clients. Our clients actually, the Afzalis actually accepted the deed and then filed a disclaimer or a protest document after it, saying they were protesting the way the deed was prepared, the inclusion of that easement. So that's a public record also. So what we're really saying that if you
was
look
the
at
deed signed by your clients?
the deed was not signed by our clients, it was signed by Mr. Etemadi.
Okay. And then you mentioned in your argument that the settlement agreement promised good title.
Yes.
Was only good title promised?
The way the agreement was drawn up, it said good title. Yes.
Okay. So, I mean, why is it that fatal to your case? I mean, good title is just legally valid or effective title. You're not arguing that the agreement promised clear title. Now, I could see your case if the agreement promised clear title, free from encumbrances, but
Right.
You're saying the agreement only promised good title.
It did promise good title, and our argument is that when you take 38% of the front footage of a commercial lot and tie it up in an easement, it makes it commercially unreasonable. I mean, it cuts off all the value of the property, and it in effect is not good title, because if they tried to sell that, they've only got a 38-foot lot that's unencumbered, and it's a commercial lot on Knowlesville Road. It's a car lot, and there's actually a building, a shed on that lot that is practically unusable if that easement exists. I mean, it's not good in the sense, if you put it on the market and try and convey good title to somebody else, they would object. And I guess the other element is just a surprise factor.
Did the settlement agreement also promise marketable title?
It did not use the word marketable.
Okay, so only good title. So the question
Yeah.
here is whether you've adequately stated a claim when the promise in the settlement agreement is only good title.
Yes. And our argument is basically when you eat up 40% of a commercial lot with road frontage on Knowlesville Road, it's not good title. It's not a commercially reasonable, valuable piece of property. And if the court will note, our clients bargained for and paid $525,000 for what, in effect, if that easement stands, is a 38-foot lot. That in itself is not commercially reasonable. And that's really the crux of our argument. Our argument is the settlement agreement was breached by Mr. Etemadi, and we have yet to be able to prove that or put that really before a court because it was dismissed. That issue never really got heard in the prior 2016 case, and so that is really the issue, and the fact there's really a quiet title element to this. If the title is obviously flawed with that easement standing there, and so what we're saying is that's not good title. And that's really the crux of our argument. We're asking the court to reverse the dismissal of this case by the trial court. We'd like to have it remanded back to the trial court so we can be heard on the breach issue and also on the quiet title issue of this property. If this stands, it basically has created a flawed title in that commercial tract. I'll save the rest.
All right. Thank you, Mr. Notestand. You've got 3 minutes for rebuttal. We'll hear from the appellee.
Good morning, Your Honor. Christopher Hugan here for the appellee, Shirzad Etemadi. I want to first say I was not Mr. Etemadi's counsel in any of the underlying litigations, and there were a total of 4 prior lawsuits about the ownership and the occupancy of this property filed before this 5th lawsuit. But there is one thing that is clear. The motion to set aside filed by the Afzalis, their Rule 60 motion, didn't simply ask that the case be reopened. It specifically asked that this easement be abolished and be ruled null and void. So it wasn't just reopen the case to examine it. The relief they sought was to abolish the easement. Now, that motion was denied by Chancellor Bonnyman. And here's the critical fact. The Afzalis did not appeal that motion, that order denying their motion. They let it become a final order. And it was that moment that res judicata applied to the issue of whether this easement was valid or invalid. Chancellor Martin, in her order of dismissal, in this case, it's the technical record at page 246, recognized that. She said, I examined the Afzali's Rule 60 motion. I deemed that they sought the same relief from that court. The court had the opportunity to rule on the exact same issue, and it was fully adjudicated. That's what Chancellor Martin said when she granted the motion to dismiss. So the Afzalis made the choice to put the easement before Chancellor Bonnyman in the prior litigation. They didn't fully litigate it. They could have appealed it. They didn't do that. What they're doing now is seeking a different result from a different court. And really,
the appellants here have said or characterized the prior litigation as basically litigation over whether or not their lease agreements provided them an option of purchase. Is that an accurate description of what the earlier litigation was all about?
That's an accurate description, yes.
So why would, in that earlier litigation, would they raise a claim about an easement that wasn't even filed until 2 years after the filing of the lawsuit? I mean, what does that have to do with rights under a lease agreement?
Before they accepted this deed, this easement was of record for 6 months. They had actual knowledge of it for 3 months before they still accepted the property, knowing that that easement was in place. So,
well, and I understand that. I mean, there might have been some negligence there in not running a title search before walking into a closing and accepting a deed. But it seems like to me that's a separate issue from, I'm just puzzled by the res judicata dismissal here, because as you're well aware, it has to be the same claim or cause of action in both suits. And I don't know why you would have asserted a claim about an easement that was recorded 2 years after the initial suit in a suit over what your rights are under a lease agreement.
Well, I agree. I think they had an either or choice. They could have let the final judgment in the prior litigation become final, then filed a new lawsuit on the settlement agreement, or they could have put the easement issue back before the prior court. And that's what they chose to do. It was litigation strategy.
So I guess part of your argument then assumes then that the chancellor was wrong in the initial suit for denying the Rule 60 motion. They should have pressed that on, because ultimately you're saying that would have been a winner in the first suit.
I don't know if it would have been a winner or not, but I think they had a duty to exhaust all of their options in the prior suit once they brought the easement issue before another court, and they chose not to do that. And that's when res judicata attached.
Mr. Hugan, you said they had actual knowledge 3 months before the settlement agreement. Is that right?
No, they had constructive knowledge because it was of record approximately 60 days before they filed the settlement agreement.
I thought you said 6 months. I'm sorry, 60 days.
And then
I thought you said they had actual knowledge before something. What was that?
right. They had actual knowledge of it, and they admitted it in their brief, and I don't think it's disputed, in late May of 2018. And then I believe they closed on the property 3 months later. So they had actual knowledge of this easement right when the trial was about to begin. And so they still closed 3 months later with this easement still of record.
So they had actual knowledge before the prior case was resolved.
Yes,
They announced a settlement. There were two different lawsuits that were combined. The Afzalis announced a settlement of their portion of the lawsuit, purportedly not knowing about the easement. Now, I think that is disputed. At least my client disputes that, but there's nothing in the record. And they say, we did not know until that about this easement until we settled it and announced a settlement. Then they went out in the hall, claimed they learned about the easement at that point. My choice would have been to go right back in that courtroom and say, we have a problem, Judge. They didn't do that. They then submitted a final order after knowing of that easement, dismissing their claims. Then they filed a Rule 60 motion to set aside that order. So they did have actual knowledge for a long time before accepting this property.
The
So
final
they had
order-
actual knowledge, then they filed the settlement order.
They had actual knowledge, and then they submitted the final order in their case. in
Okay.
their-
You said they submitted the final order. Was it an agreed order or was it an order reflecting a judge's prior determination?
It was, I'd have to take a look at it, but it was an order prepared by by the Afzali's counsel saying, we have settled this case and we dismiss our claims. And they at first, they said it was an involuntary dismissal. I mean, a voluntary dismissal without prejudice. And Chancellor Bonnyman at that point said, we can't do that. We have two people claiming ownership of this property. This is a final judgment on the merits. And so Chancellor Bonnyman penciled in some alterations to Mr. Notstein's order, and that order ultimately was entered on, I believe, June 7th. The settlement agreement was entered on May 25th.
All right, thank you.
So it's our position that res judicata does apply. It applied when they failed to appeal that Rule 60 motion. Now they asked to be relieved of res judicata on the basis of equitable estoppel. There are three elements of equitable estoppel, and I believe they fail on all three of the elements. The first one is there has to be a false representation of a material fact for it to apply. The second is the Afzalis had to rely on that fact, change their position to their detriment. And then third, they would have to have no knowledge of the false fact and no ability to determine the truthfulness of the fact. So let me look at the first element. For equitable estoppel to apply, there has to be a false representation of a material fact. What the Afzalis are saying were false statements were two short legal opinions in a memorandum filed by Mr. Etemadi's counsel in the prior litigation, where he says, I think a better procedure would have been to file a new lawsuit. And that's not necessarily a false statement, but more importantly, it's a legal opinion. And legal opinions do not constitute false statements for the purposes of equitable estoppel. I cited many cases in my brief, but I found one over the weekend that I did not cite in my brief, and I'd like to bring it to the court's attention. It's Boyce v. LPP Mortgage Limited, 435 Southwest 3rd, 758. It's a Tennessee Court of Appeals case from 2013. And at page 772, this was addressing equitable estoppel and a wrongful foreclosure suit. They said the opposing party must have either concealed a material fact or made a false representation of material, quote, facts either past or present. It says legal arguments, however, are not facts. So this same issue came up in this Boyce case of was a legal argument a fact as it applies to equitable estoppel? It's not. Black's Law Dictionary says law is a principle, fact is an event. So when Mr. Etemadi's prior counsel complains that these legal opinions are fact, they aren't. They're legal opinions, they don't qualify, they don't satisfy the first element of equitable estoppel. The second one is equitable estoppel requires a false fact, reliance on the fact, then changing your position. So the false statement has to come first. The operative act that caused the res judicata was the Afzalis filing this Rule 60 motion and putting this easement squarely before the prior court. Then prior counsel filed a memorandum with these statements that the Afzalis now claim were false facts and they relied on. It's out of order. The statement didn't come first. There was no reliance. The Afzalis could not have relied on these statements because they had already filed the Rule 60 motion. So since these events are out of order, the second element is not satisfied. And third, and I think this is the most important, is as far as these purported false statements that required for equitable estoppel, they had to not know the truth of them, and they had no ability to determine the truth of them. The Afzalis were represented by counsel through this entire proceeding. So whether it was true or not that a new lawsuit was more proper, it doesn't matter. They had the ability to determine whether that was true or not. And I think the Sexton case that I cited in my brief was right on point. This was the one where the judge in Sevier County, judge, asked that he be paid the exact same salary as his predecessors, but his predecessors were not paid according to law. There was extra money that should not have been paid. When the plaintiff in that one realized the statute was clear, he wasn't entitled to extra compensation, he said, equitable estoppel, you paid the prior judges, I need to be paid. That was struck down. That argument was rejected by the Court of Appeals, and it said there can be no estoppel when both parties have the same means of ascertaining the truth. Obviously, the Afzalis had the means to ascertain the truth of these purported false statements, which were legal opinions. So all three of the equitable estoppel arguments fail. Now, quickly onto the waiver. Chancellor Martin also said in the settlement agreement, the Afzalis waived all claims against my client. Now, what the Afzalis are saying is, wait a minute, we waived some claims, but we didn't waive everything. We reserved the right to contest this easement. There's nothing in the settlement agreement that says that. There's nothing in the deed that says that. And the waiver, I think, is pretty clear in the agreement. It's at Technical Record 123. It says, upon closings, buyers and sellers will release any and all claims against each other as to the breach of the Afzali lease and option to purchase. That's the first part of it. So that's what this entire dispute is about, is the lease and the option to purchase. So I think that was a waiver of any claim against about the easement. But the second part of it says they also waive all other claims relating to or arising from similar transactions or occurrences. That language, at least the second half of that sentence, I don't believe is particularly precise as far as what similar transactions or occurrences are. But I think one thing is that it doesn't limit the release, it expands it. It just expands it. So
was the waiver agreement signed before the deed was conveyed?
Yes. It was part of the settlement agreement.
Then how can it apply to the deed or any misrepresentation in the deed or action giving rise to the deed?
Because the language in the waiver says that it becomes effective upon closing. So when they closed on the property 3 months later, the waiver became effective. So I think that you can interpret that language to say there is a hidden reservation of right to sue. I think that would defeat the purpose of the language. Even though it's ambiguous, there are canons of interpretation that I know the courts are very familiar with. We shouldn't interpret agreement to destroy it. I think that was an omnibus release, and they released Mr. Etemadi completely when they accepted that deed upon closing. Finally, I only have 15 seconds. You can affirm the decision on alternate grounds. We pled the doctrine of merger that says the settlement agreement to convey the land was an executory contract. Anything in that settlement agreement merged into the deed, and the deed is the final contract.
Thank you, Mr. Hugen. We'll hear from Mr. Notestein now.
Thank you. He brought up some interesting, very, very well presented. But I want to, all this discussion about equitable estoppel, the fact is there's nothing in the decision from the trial court that indicated that was really even considered. She looked at res judicata, she looked at waiver. The court looked at the closing and said that waived the right to bring these claims, but didn't even really address equitable estoppel. And we feel that that should be applied when there are inconsistent legal opinions and factual positions.
Was it presented in the pleadings and argued before the court?
it was presented in the pleadings and it was brought up before the court, and for some reason it wasn't reflected in the decision.
All right, thank you.
I wanted to correct the order a little bit, and unlike Mr. Hugan, I was there when this happened in the prior case, and we actually signed the settlement agreement in May, came to court, announced to the court on the record that we settled the case with Mr. Etemadi, and then went out in the hall, and counsel for Mr. Etemadi advised counsel for the Afzalis that there was some kind of vague easement there we might want to check into. And based on the settlement agreement being signed, we submitted a non-suit order without prejudice in case something else could come up. And for some reason, the chancellor changed that to a dismissal with prejudice. And we don't know why. And that was one of the reasons for our motion, to try and clarify why that was done. The chancellor did not change her position. The court should keep in mind that this was in May. There was a settlement agreement signed in May saying that the Afzalis were going to buy this property by August 31st. And there was no contingencies. They had to buy it by August 31st. When they dug into the easement and found out that it took almost half their property, front footage, in the form of an easement, they protested, but they also did not want to be in breach of the settlement agreement. They felt Mr. Etemadi was breaching the settlement agreement, but they did not want to be in breach. And therefore, they felt like they had to close. Their business was there. There was no further lease. If they didn't close, they'd lose their business and lose the property. And that's why they wanted to challenge this easement issue. The notice they actually got was after the settlement agreement was signed. And there was the deed was negotiated, and Mr. Etemadi's attorney did not change it. They prepared it with the easement reference in it. I might add that if you look at the easement in the record, Mr. Etemadi did not use his trial counsel to prepare that. He went to a different attorney in Franklin and had the easement prepared and then recorded it. So,
Mr. Notestein, why didn't your clients appeal from that order, the 2016 order?
For two reasons. We did not think that the motion or the basis of that case was a quiet title or an easement dispute or a settlement agreement case. We felt like that case was over the lease and an option to purchase. And we felt that it would be best to file a suit for breach of the settlement agreement and quiet title as to the easement. And we based that on part on Mr. Etemadi's counsel in open court saying that was our remedy. And the court seemed to affirm that, that basically that was a separate issue. And so that's what we did. We let that stand and then filed a new lawsuit. And that's where we're at today.
Very good. Thank you, Mr. Notestein and Mr. Hugan, for your arguments. We will take the case under advisement. Mr. Hibner, you may conclude this session.
The court is now in recess until 11 a.m.